Who's in that now?
Is everyone ready?
Yeah, I'm good.
Alright, component ready? Judges ready?
The standard is combating social violence and restriction conditions prefer one. Status motivation to conversation about everyday violence. Only a friend with the great space for finding solution is productive and ethical. Smith. 13. The reality of racism based consequences of the coaching students make abstract this the conversation be up to the only constructive strategies to acknowledge the process to engage discussion and define strategies to the issue that anyway others should not have to define why oppression is bad. Debate is a learning environment of liberatory potential question competitors misconstrues of exclusion won't teach anything other than how to shut down competitors to engage in fear structural discrimination. We can retreat or cause neutrality and second material conditions confers moral theory. Starts with material blind someone, whatever they think of a moral system, they didn't like the current situation, which they must have. If you harm material harm, they wouldn't care enough to start thinking why it is bad that this is occurring. Advantage, genomic racism, current law allows prosecutors to offer plea deals and exchange for DNA samples. Circumventing legislative regulation of who must contribute DNA. Murphy. 17. Under fundamental law, police have broad authorities to seizure genetic samples. Prosecutors may offer plea deals based on assertive DNA. These answers can circumvent legislative judgments about who must contribute DNA. The prosecutor can condition all favorable plea deals under relinquishing genetic material courts. Treat generic material as assertive voluntarily paying insufficient accuracy to the physical characteristics of material samples, and police officers can choose to arrest anyone subjecting them to plea deals in exchange for their DNA, marking them as a permanent suspect for future screening racial bias, and arresting and conviction. Ensures this is used as a tool to sustain a genetic racial in order to implicate racial minorities in future crimes. Roberts in 11. California arrested for felony can be compelled to provide DNA. All this requires themselves to decide to make an arrest as a person become a permanent suspect of genetic information range database for each screening. The U.S. has the largest database of DNA because of rampant racial bias. DNA databases being amassed into obscure race-based biotechnology DNA repositories which are gathered for the implicating people in crimes, and biometric surveillance that justifies false accusations and disproportionate criminalization of racial minorities due to psychological bias, the myth of DNA infallibility, and the lack of resources to challenge accusations. Roberts. 11. Bracketed for gendered language. Racial disparity in the database make communities and colors most vulnerable to state surveillance to intensify the racial disparities in the database. False being accused, blacks and Latinos are at a disadvantage. They have few resources to challenge mistakes. They are stereotyped as criminals before DNA. These studies make them more vulnerable in the midst of DNA fallibility. Psychological studies show across racial identification DNA extracted from the guilty and innocent black people will magnify stereotypes of black criminality that lead to wrongful convictions. And genomic racism is a new biopolitics where the state controls life and death through classifying races. Impact is massive. There are more modern slaves now than in 1860. Roberts. In 11. The ideology of racism, the natural division between human beings and our genes. Can conserve the enlistment for new biopolitics would say power control the life and death population relies on classifying misvaries. There are more blacks than ever controlled than there were slaves in 1860. Biological distinctions appear to explain why stark racial disparities. Researchers are increasingly asserting that genes determine behavior. Solvency plan resolved. The United States Supreme Court will abolish plea bargaining for DNA by finding the exchange in violation of our Fourth Amendment right to be free from searches and seizures of probable cause. In the next possible test case, the plan solves legislative effort to keep Brosnack. 11. The ease of dropping severe charges in exchange for DNA resulting containing DNA by innocent people. The Orange County database unfairly brings innocent constitutional rights to privacy. These theories of voluntary unauthorized expedition of the legislation, the boundaries of criminal law and practice privacy concerns raised by this deserves thorough consideration by the legislature. The court found the Orange County system involuntary that the program could violate the Fourth Amendment right to be free from search and seizures, and the plan is key to accountability. Current programs lack oversight of Brosnack. 11. And broken on the legislative programs, and the absence of the legislative process means an absence of accountability and oversight on the programs enacted by the legislature. The only oversight comes from the rules set upon by the founding executive branch actor, and plea bargaining usage and this instance is not constitutional. Brosnack. 11. Normal sentence have legitimate privacy. The rationale for collecting DNA for prisoners not applied to the sentence. The only method by which law enforcement can obtain a normal sentence is through converted voluntary DNA sampling. The Fourth Amendment expectation of privacy protects citizens from such tactics. There's no Fourth Amendment expectation of privacy for an event item of arrestees. Expectation of privacy might be temporary depending on whether the arrestees are convicted. The DNA database will not bring DNA for arrestees who are convicted. The method, the role of your values, you value the desirability of the act policy versus the status quo or competitive policy option preferred. 1. The act deploys the state to learn scenario planning, even if politics bad. Scenario analysis policy is pedagogically valuable and enhances creativity because it requires institution actions which create the ability for a better future Barna. And all 16 scenario analysis with control alternative or the ability of decision makers to impose to imagine is constrained by existing mental modules and cognitive bias. Scenario analysis to help that individual work out of mental most of thinking individual, thereby adapting different from the present, cut the card present. And second, the act deploys the state to recalibrate. We don't ethically legitimate. We are in the best mission to expose computer and not in 3. Those cognitive power can best expose to it actually allows the opera domination. The person is specifically the series of the machine to calibrate partial with the opposite function. Third, making a man state and questioning her on a method to work outside the political order to question its legitimacy. Newman making a method state does not work in state of reforming demands are made from an outside political order. The equation of legitimacy and the sovereignty of the state by highlighting fundamental state practice and 4 prior questions will never be fully settled. You must take action even under circumstances or conditions of uncertainty. Cochrane 99 is important that we proceed with the analysis of imperialist holds for all theories of the inclusion of the present climate of epistemological uncertainty important political concern hanging balance. We cannot afford to wait for the meta question to be answered. I don't wait for credibility of alternative orders here before it. Educating make a degree sorting out the theoretical issues and working on a credible institutional vision. They two can be persuaded together. And 5, reject high impact scenarios. No low risk is no risk. Debaters cognitive bias is overestimate basic impacts code. 13, investigate judges assess nuclear war and existential policy based won't replicate real policies is unreasonable. The measure when an argument starts at 100%, but is really tough to reviews on the answer 0. This adventure underpinned by hundreds of assumptions. But the majority's conceded was to make definitive claims of uniqueness says there may be one of far less than 50% of the impact is a long string because the risk is at a very low level for the even offers direct response. It doesn't take too many to reduce to effectively 0. Next is a theory interview 1 theory minute. Theory is otherwise like me if so much always because one sees more time to be so also drop the beer because 1 minute it doesn't have enough time because then one of the theory says you must be punished. Second only actually skip RVIs. Actually skip all that. We're done. I'll send out a read doc.
No, it's okay, don't worry.
I just read 1 year very good.
Yeah, don't worry, you're good.
And also I cut out 1 word of one of the taglines. Is that an issue?
No, it's totally fine. I got it all. All right, ready?
Yep.
Okay. So, material conditions, this just means that we have to look to consequences, correct?
No, so saying that like the solutions that we propose must have like a material change or could conceivably have a material change for people's lives. Would you like me to go through like the why?
No, I just want to clarify that if I give an argument as to why you end up leading to more oppression, does that turn under that?
The framework is consequential.
Okay, perfect. Then let's go into the advantage. So right now, or how does the 1AC solve for racism?
So we don't like say, oh, no more racism, but what we say is that people like can't put these people in these databases and then like look at their DNA for like hundreds of other crimes, even if they get off for one, and perpetuating them to more incarceration and more cycles.
How many black people per year get incarcerated because of this DNA database?
Our evidence doesn't have like a specific, I don't know like a number off the top of my head, but our evidence indicates that the United States has the largest database for DNA, and that minorities are targeted like by police, and their DNA is put in there and it doesn't get out. So even if they like are dismissed of one crime, they're caught guilty even falsely most of the time.
Okay, so we've done things before where we've tried to be able to like create like body cameras and stuff like that, and yet police still discriminate against black people. What does the 1AC do to be able to solve that?
So we don't say like police will not be racist, but we take away some of the tools that they use to harm African Americans and Latinos specifically. For example, when someone's like...
So just DNA testing? All right, actually, let's just go into the solvency really quickly. You defend SCOTUS, correct?
Correct.
Can you point to me any piece of evidence in the solvency section that's about SCOTUS? They're all about the legislative branch.
Yeah, so Varsadec 11 is specific to the SCOTUS is key.
Where?
Like the the argument is about Orange County.
Can you point to me a line?
Yeah, if the court, the privacy concerns raised by this deserve thorough consideration by the legislature. If the court found that Orange County has been voluntary, the program should violate the Fourth Amendment right to be free from procedures absent probable cause. This would indicate that once the court would rule this unconstitutional, which it is, then the legislature would also have to progress or would not be able to like reverse this, and this would be something that is adopted by like states because like the way that federal laws work. Once it is unconstitutional, then they can like reverse it.
Got it. Okay, so let's talk about the plan text really quickly. So do you only abolish plea bargaining in the instances where the prosecutor requires them to give up DNA?
Yes.
So let's say that okay, got it. That's fine. So the legislature, does the 1AC feel that the legislature takes action, or just that SCOTUS takes action?
I guess just that SCOTUS takes action, but we make arguments for why the legislature would follow through.
Would inevitably follow through?
What?
Oh, it's okay. Yeah, that's fine. The first card, the Murphy 17 evidence, indicates why current measures are circumvented by prosecutors. What does the 1AC do to stop this?
By making it literally like unconstitutional and illegal.
It was unconstitutional before. Your evidence indicates that.
So the evidence indicates that if it was if this was like the Orange County case went to the Supreme Court, it would be ruled unconstitutional, but it hasn't yet.
Okay, but what is ruling it? Has it not been like put in place as unconstitutional?
It's like in these circuit courts in like California and Orange County. I don't know where that is exactly though.
Okay. I will send it. The order is going to go for off and then case. On case, it's going to go the framing mechanisms and then theory.
Let me open up a spreadsheet real quick.
Sorry?
Can I just open up a spreadsheet to,
Yeah, you're good.
Just so you know, I'm like looking at the case on my phone. I'm not like chilling on the phone during your speech. You said 4 off?
Yeah. Let me know if you need more paper. Yeah, 4 off. And then on case, did I just say the method and then theory? Sorry, can we go 4 off, then advantage method theory?
You're like a ½ centimeter too tall for this camera.
For real. How tall are you?
There
like
we go.
5'7.5", or like 5'8".
That's really tall.
Let me know when everyone's ready.
all those things. Did you send the email?
Sorry?
Did you send the email?
Yeah, let me know if you have it.
Oh, yeah. I'll download it right now.
I'm good.
Yep. Alright.
I'm almost there.
Yeah, do it. Good?
Yes.
Alright. Interpretation and violation of abolish means all laughingly when the subject one abolishes whole Supreme Court of Florida 58 abolishing to do no matter the size or rate of rapid non-abolition inherited. Any speak the normal meaning of the term abolish is complete destruction as long as the question. Few any class of force search uses force search is non-abolition. B. Instruction for one the affirmative interpretation that means the world during there is allowed to logical. Limit on topic explosion Hargrave 98. No abolition be passed abolition for such a meaning of abortion cannot be. 2. It cannot be done with only abortion ignores for being difficult position legislature can severely work institutions long keeps the man limited minimum. But target the reason difficult minimum. 7 minute force should have to be abolished difficulties in determining that point. 2. It's burden their community comes to listen single birth. There intervenes only that for one of the things has prepared thousands SBC many types of crimes violence property white collar organizing sexual within each kind of which for crimes exist in there are multiple kinds of plea bargaining validity. There are many destructive legal hard bargaining counter bargaining sensitive bargaining back bargaining. C. It's not without explaining predictable evidence tells them what they do and do not have to be prepared for it to be valued through logic and interpretation. It's not what you do, it's what you justify in. Nor we have stated that which go on in theory. And B is a B is human theory, I mean, which means that theory is typical without a state's counterplay. Federal counterplan will have the 50 states do the Supreme Court. The courts of the 50 states do the entirety of the affirmative. We'll specify further if you need us to instead of cross-ex if you're confused on the plain text. But if you're confused on the counterplain text, and I can also write it out for you in cross-ex based on your exact claim. You should prefer the spirit of the counterplain text over the actual text of the counterplain text, especially when its plain text is so confusing and long that I was barely able to understand it. And federal enforcement fails. Local prosecutors circumvent feds don't have the money to enforce the FFF. 18. The CTS is according to laws passed by the state legislature. Where do we see the benefit that is going to shape the policy? They only do so interact with the federal laws, and the DOJ has no oversight authority over the state local law enforcement in New York after 6 years on the CJ. After some local conditions limiting the impact of federal legal aid. D. State legislators to crack down on drugs local prosecution from the local conditions to the Fed. Does not have the money to spend the state behavioral spend. State spending $200 billion per year on the CJ while the DOJ budget is $20 billion. The Fed grants come to about 1% of state and local funding. And actually, just the counterplain text. The courts of the 50 states will eliminate plea bargaining for DNA by finding the exchange violation of our Fourth Amendment right to be free from teachers and teachers after probable cause in the next possible test case. I can write that out for you next, and I have it on recording if you need it. Decide. Gerrymandering. One deal is a test case for gerrymandering that will most likely sway counties vote to be against gerrymandering has in 1215. Counties in the middle of New York, the has liberals proposed more deal of the division in County County was sympathetic to Wisconsin challengers. 2 is counties sometimes the rights of defendants perceived as bullshit. Limited to the Supreme Court rule. That's like the supervision of the CGS is to mean what used to be unregulated when it's not subject to constraints. Criminal justice today is not trying to go right after it. Council can move without taking account of the PP. County was enclosed to the coastal government and alignment has originated in the senior family sense of your playing. 3 is the offender of the Flip County votes you believe in all liberal system considered 1 film in 10. 5 county comments during the gerrymandering use of feelings violation by the 50 cents for the shape electoral policy to sour flexible trouble with advocacy in counties yellow as the swing vote counties have division rural decision alongside actions of regions conservative. 4 is case of isolation election states the wise key to be break GOP strangle hold on Congress and flag the 927. Guilty work seeks to declare extreme parties and register certain under constitutional court system will profoundly impact election. Each one public state legislature to institute and control by all civil voters $100 also legislative election to be ordained the party that controls has been system and human is not conducted. Oh, happens in North Carolina. Wait, sometimes Sandy County might have no greatest method. 2 besides the level of partisan reaches to the happens in peaceful, maybe the quality of democracy getting local like movie system. And 5 is continuing to be government system of first policy defense. State level North Carolina instead. 14. The Republican Party is increasingly made of foreign policy defense also means advocates for structuring the there be no whether there can be more dangerous violent policy than more religion beyond me will be behind fostering more than what would be disaster is a catastrophic solution in the country results as make refugee crisis. 6 is no scope and trust in every other major nuclear power Benjamin. 17 more than the green person to the logically drawn nothing nuclear power Russia and Russia, Japan, and in this region also have the most militaries and economies that will have the world population and North nuclear capabilities to be in green work in the spectrum of nuclear with rational policies, 1 de-escalation, 7 is the GOP is also terrible for minorities, tax reform, healthcare, the list goes on, federalism. One state, no change, genocide, and federal now for the power, wrestling, legal government, still government, translate, no change, general, use, constitution, constitution, to the this by mutual, as I say, like, issue, laws, excel, these, other Trump series, it's like, just stable, regions, organizing, for Trump, the city, issues, looking, when you about the first, simply looking at how to different themselves, better, breach, about the United States, after looking for legal arguments, supposed to, avoiding conflict, two is federal convention, constitution, change, federal authority, that, let's grab the wrong photos, and the president, to liberal right, fishing the central prosecuting, from constitution, prosecuting, the federal, and authority between the federal and the state, federal, and 8, dual agency government structure was 8, 7 government agencies and public country protected advice and decentralized government, 10 individual liberty by deleting power of the central government, federal and rotates of down files and hearings of across any prosecution diagrams for the criminal case or regional one government commanded by the other federalism protecting from it, a central government authority criminal defendant extremely vulnerable, 3 is decentralized federalism critical to protecting environmental protection, maintaining climate change, centralization, field farm 14, the decentralized policy environmental protection, development policies, addressing climate change, development by federal, main comparative living coordination, main marginal and factoring essentially operated violations into the government policy, larger state control pollution, imperial factor increase the dominant decentralization now, sir, policy matters to the local nations not included, raise the power centralization, some change in other activities, local state movement, and duration and strict dependence on your operating confident limitation of cellular life, political world deficit, combining mechanisms of the original government directly and charge and relevant response to local search, better position, martial compromises, better skilled and motivated to innovations, local teaching may facilitate government self-governance, and 4 is extinction towards 16, competition to raise the American student raise the probability of other resources and just tax money on the global glass from global systems that agriculture in Ukraine and cut the card of the Ukraine 5 is warming fertilizer individuals must only the leader able to arrive in a world where the warming aware countries in Africa get together in a world where scarce resources only wishing to live now case. The advantage area, minorities still end up getting screwed over. There's just when we shift other messes, if you don't know, minorities end up getting screwed over. If they even if they get rid of DNA, our arguments that they'll end up just getting screwed over in other ways. There's no way that can be able to solve for the racism and the status quo. They may be able to solve for a small percentage of it. It definitely means that the dissent should be able to weigh any risk in the case. The method, the competent evidence, this is an argument for the negative. It's a reason as to why we need to prevent extinction, because if there's uncertainty, then you want to err on the side of protecting the human race. Skip the first card, now go on the cone evidence. So one is probably doesn't mean disregard extinction, maybe specifically why it's likely to drop the legal system and require things like maximum expansion of budgets. And is very liberal decision, which means that we have a high probability of this occurring. 2 is probability makes a question scenario make the answer of lynching. In other words, there's 100% probability. 3 is turns the case and since their impact from this that turns the case of rational policy maker but disregard massive impact. 4 is the counter themselves. The case of the probability impacts are non-unique. 5 is consequential of this key. Otherwise, race discussion purely ideological and never cannot impact race. 6. Reducing conversation race around between ideological context allows opponents to allow you for another particular policy or design principle and ideological seem to create the emergence of policy is the embodiment of some higher moral principle that brings the person and itself without words to the outcome. No process has come to be understood as embodiment of what is just and independent of its actual person life, minority, existing racial disparities in health, wealth, and society. In terms of being purely ideological terms, opponents are able to avoid the contentious and use the outcomes of ideological exchange further exacerbates hostilities and deepens the cycle of resentment. And 6 is episodic modesty breaks any ties and answers all AC preempts blossom 12. Women are outcomes and making up the big one if we are thinking about any serious great value preserving the future. But recognized value into the future according to there will be a future of humanity's best way to increase quality of the future will need a lot of value. And also we've impacted out all of our impacts in terms of minorities, which means that we definitely are able to link on your framework. The theory flow drops of leadership not about the students. We should make it most proportional punishment. Otherwise we're never really engaged on a substantive level with each other, and we just end up going into theory debates every time, and the 1 AR just devolves to that.
Alright, see ya. Alright, ready? Status of the counterpoint.
I'm fond of.
Alright, cool. So let's talk about the evidence in this counterpoint specifically. Is your counterpoint solvency advocate specific to 50 states in the instance of the AF, or is it just like 50 states in general?
Well, first of all, this was a new AF, so
okay.
I barely had any time to prep. So if you're asking for a hyper-specific solvency advocate, no. In the 10 minutes after we flipped, I could not find a hyper-specific solvency advocate to your hyper-specific AF, which doesn't have a solvency advocate either. Okay, that's fine. So let's talk about the disadvantage. Actually, let's talk about federalism. So wait, your missile evidence says that states are fighting right now. What means that, like... State attorney generals. Yeah, state attorney generals are fighting right now. How does the, like, what does the AF stand, or the next stand for this? Is that, like, fighting that are good or bad, necessarily? We say that the states being able to look for ways to challenge federal overreach is a good thing, because we need to have a balance of power. So a balance of power between the states and like, government.
heard.
Well, so the idea of federalism is just that there's a balance of power between the states and the government shouldn't have like too much power. Our argument is when the president does something like kind of foolish, the state actors are being able to make legal arguments as opposed to avoid looking for conflict, which was previously done in the past. So under Obama, it started increasing. The state attorney generals would challenge more, but now under Trump, it's like exponentially increased, such that there are tons of state attorney generals who are now challenging things like federal overreach and things like education.
But why is federal overreach bad? If federalism without a balance between powers, wouldn't it be good if attorney generals are checking back?
Well, so I think you're misunderstanding. There's a difference between federal power and federal overreach, right?
Okay.
So federal overreach is the idea that the Fed is going into areas where they shouldn't be. Education is a really good example of this, where, yeah.
That's fine. What makes the app specifically like so much overreaching that it'll show you the link?
So there are a few things. It says that centralized, or like I can just read you lines from the White 15 evidence. It's pretty good. It says right here, absence federalism's protection from a centralized governmental authority, the individual criminal defendant is extremely vulnerable. That's one part of it. 2, it says cross-designated prosecutors has dire consequences for the criminally accused. Overreaching by one government cannot be prevented by the other. Cross-designated prosecutors is when prosecutors have to deal with both federal and like state mandates, and like right now the states are the ones who are currently dictating what federal prosecutor, or sorry, what the prosecutors can do.
Okay.
And that's in our evidence about why the states are the ones who are.
So did you read all these justifications for extinction first, or did you skip some?
I skipped the 1 point, and then I skipped the 8 point at the bottom. So I just skipped 2 cards, but everything else was read, yes.
All right, cool. Let's talk about some of the specific warrants there. Let me get over to you. What is the warrant in the, so you get the 1.2.
And the 2 point?
Why does it, okay. Let's talk about the ratio of 6 evidence. What is the, how do we not like, are not consequential?
No, all our argument is that if you were to try and preclude us by being like, well, you don't talk about race, our argument is that we have to look at other consequences as well, and we've impacted them out to race, so you can't just disregard it by being like, well, you didn't have a card that was like, black people get harmed.
All right, cool. Starting now. Are all these just reasons why mortgage of the extinction matters rather than like free fiat reasons of value extinction?
That was a lot of buzzwords. I don't know what you're asking.
Are these like reasons to pre-fiat refer to extinction, or reasons why like as a framing issue extinction is good to talk about?
I'm gonna try to answer this to the best of my ability, but we just say that we should focus on the consequences of the plan if they produce extinction.
Okay, that's fine.
All of our offense is about the consequences of the plan, if that's what you mean.
That makes sense, yeah. What were the verbiage you read on T?
The voters, we made limits arguments. I mean, if you want me to be like, fairness is a voting issue because, you know.
Did you read those in the class speech?
No, why would I have to be like,
Okay.
education is important?
That's fine.
But like we said that topicality is a voting issue for predictable limits, tells the negative what they do and do not have to be prepared for.
Okay.
I can read those in the NR if you need me to explain why fairness is
That's fine.
important to read.
Order is going to be T, F.
On the F order.
Advantage, solvency, then it will also be the T, F. So T, F, then it will be gerrymandering, counterplan, federalism, counterplan.
For T, are you starting with a counter interp or on her interp?
No, counter interp and the original interp.
Is there a doc?
Oh yeah, it's just going to be the bottom of the old doc.
Alright.
And there's going to be a dissad talking about both overviews. Actually, never mind. I'm not going to do that.
Okay.
It'll be in the doc, but I'm not reading it.
I'll follow along with the document.
Cool.
So it's going to go T, advantage, gerrymandering, federalism, states.
Yep.
You're not, okay, yeah.
So once again, order T, F, gerrymandering, federalism, states.
Okay.
Give me one sec, I just need to open it.
Let me open up the doc.
It's at the bottom.
Yeah, it should be at the bottom. It'll say like 1 ART, 1 ART. There's nothing under T.
Yeah.
And the overview of the dissets, I'm not reading that.
Okay.
Everyone ready?
Mm-hmm.
Alright, cool.
First, we read the text of your chart. We completely do with bargain, for instance, the DNA and the DNA sampling. Second counter-interpretation may only remind select elements arguments. There's only one after about. Third counter-interpretation is the controversy of your interpretation with the added planks of telling you the plan text and also having a solvency advocate. That's the first piece. That's the first piece of evidence in our solvency. Now, for further interpretation, one is over-limiting. Under your interpretation, there's literally only one half people can read. Even if you can have different forms of plea bargain, there's literally the same arguments apply to all of them, which kills innovation. You should err towards less limits to the TOC topic. We should have a unique opportunity to go in depth. Now, second reason prefer is depth of discussion. We should, if I read a plan, I can get into like a deep discussion, 45-minute discussion, which outweighs everything else because we can't, because we can never have like any good education. We focus if we focus on like multiple different issues, like reading like does advantage this. Now, off interpretation proper group all the cards they read. There's no jurisdiction voter, so there's no reason to vote on this. Also, no jurisdiction voter. People vote on non-solvable class all the time. Now, now group these and now group the limits. And the first of the two there's one is that your interpretation laws picks out of anything a couple impacts. One admits your non-use your limit standard because of infinite outplaying take a pick out of. Also, B1 is that it outweighs because it picks systems what is often tell. Second, there's no impact because also have to prep out every single app and also profiling the effort that can have any more prep than you. There's no impact. Now, also, we control the internal link or actually, third is that there's no internal link to engagement. They definitely can't engage regardless of anything else. That is the only vote of the read. They don't read any fair education, but it's controlled the higher standard of the next page. Now, the app. Case goes functionally conceded right now. Prosecutors can force people to give up their DNA samples and put them into a database for endless time. That increases wrongful conviction and increases the idea that the DNA is completely infallible. That means that there are more people under modern day slavery than there were in 1860. Outweighs the case. A1 is string doubling. They literally have conceded functionally all our impacts. So whereas we're going to put some defense on the dissent. Also, B1 is on reversibility, or B1 is on duration. This will last for dozens of years in the future. And also C1 is that reversibility, wrongful incarceration. They're stuck in their prison. That means they have to live a life of social exclusion, which is what artifact evidence indicates. Now, specific off their argument, they say we're not going to solve. The people are still going to be racist, but even if people can still be racist, we are going to take the tools away. They can do everything else. Now, also extend the Smith 13 evidence from the framework that indicates we have to look to structural violence. Anything else, even if extinction matters, you should use structural violence as a impact filter. Impact filter. This they can still get access to extinction impacts. They just have to look through everything else. Now, gerrymandering. One uniqueness overwhelms the link gerrymandering is already going to be structuring errors to prove the plan will make Kennedy switch on gerrymandering and then let the decision after gerrymandering might be affected. Now that a little decision before gerrymandering will affect the gerrymandering. Second, the guilt case has already been heard, so the decision on the effort will be affected because it comes after the case. It will change the the third degree your fellow man check alcohol gerrymandering could affect after the wedding cake is now not effective liberal case gerrymandering will affect the wedding cake is now 4 has evidence proves influence of others where people are really think you're in will be unconstitutional liable and all of your arguments you say that GOP government destabilized North Korea but no it's not unique it's already destabilized we no terminal impact now off federalism skip that card. Federalism wrecks nations for economic growth. Risky 09 federalism become a serious impediment to reversing the downturn of ethical responsibility at national levels. Single out and state that the opposite of having states fiscal quality, even if pro-cyclical, even absent federal government's borrowing over money, the companies are effectively taking out the card out now. Econ collapse, extending the rates of the possible 15 interpence rates of the cost of conflict leaders anticipate decline the ability to limits and forces to reduce more security risks that changes in the world economy after circumstances the way the ruler and state appears to be regards terms can be lose credibility always your evidence because it is specific to a reactionary leader election, which means more in line with the current climate. Now the states federal policies prefer more of more cost-effective healthcare hours and social security improves. Lower secondly, there's little evidence that the states are more efficient than Washington. Delegated programs that may be good experience with programs offer more than improve the efficiency of social security makes about the 60 million rates with lower overhead. So one with the internal order service efficiently with the countries now. Permutation do, but the reason why 50 states and the Supreme Court can at the same time now. Perm shields linked to the dissent because we're going to be showing that people they're going to work in unison, which is what federalism is. That's ethics explanation crossing hold into now. Multi-actor field is illegitimate. 8 points that it's not real. Well, no one's. I just skipped that part. I'll sit down and do everything I did great.
You skipped multi-actor fiat?
Yeah, I didn't.
Okay. I had 4 minutes. Could you write out the counter interp, or like, do you want me to do that during prep?
Yeah, I'll write that out right now. Actually, there's actually 2. I'll listen to a new doc of everything I read.
Awesome.
I'll try and find the part where I cut the card. Yeah, I got it. It's highlighted in yellow. It's directly.
No, I know what it said.
Yeah, especially. Alright, let's send it out. I'm gonna get some water just real quick.
Did you guys get it?
Huh?
I'm just asking. Oh, I just got it. Never mind.
Okay.
Thank you.
Yep.
Great. I'll start. second argument you made under limits? You said there's no impact because we have prep.
No, so the second argument I made under limits, switch side debate solves. I have to prep up every single app and frontline the app.
Got
so
it.
it's possible of having like, way more prep than just flow.
So really quickly, just on T, you made the we meet the two counterinterps, over limiting depth of discussion, picks, no impact because or switch side debate. There's no internal links because we could engage, and then there's no fairness to education.
I didn't say they weren't voters. I said they weren't in the one end.
Yeah, and that was it.
That's all I remember. I don't know. Wait. Say those again.
It was we meet two counterinterps, over limit depth of discussion, picks. No impacts because switch side debate, no internal link because engagement, and then the two weren't made in the fairness and education stuff.
Yeah.
Okay, awesome. Brilliant. I will send the document. Quarters. Wait, is this? Oh, quarters. Great. Document sent. Let me know when everyone has it.
What is the order going to be?
Top Cali. But on T, we'll do my interp, your interp. And I'll make sure to signpost where I go in the document. Because I don't know if it's totally. Actually, sorry. To make it in order, let's go your interp, my interp. So the counter interp, then the one and C interp.
Any overviews on T?
No.
Okay, can we bring the order back again to just T, right? Just
Yes.
T?
Just
My girl.
the counter interp, then the interp.
You read my philosophy. Speaks my language.
So counter trip, inter.
Yeah.
Okay, my bad.
On the counter interp, it's just gonna be like a mini overview. We really don't want to do it. Only our interpretation is grounded in the resolution. You did not read any sort of definitions falling under your counter interpretation, which proves that your counter interpretation is arbitrary and self-serving, which definitely proves the limits arguments. In order to be able to win a T debate, you need to read a definition. Sorry you end up losing because you have nothing about this that is grounding in the resolution. Maybe in the abstract your interpretation or your counter interpretation might be a good thing, but in the context of this resolution, only our interpretation makes logical sense. Now, we'll go in the line by line. First on the we meet arguments. No, you conceded way too many definitions, given that you haven't read any, to be able to win your to be able to win a we meet argument. You've conceded first the Hargrave definition 83, which is really good on this, which says that as long as any proportion of plea bargaining exists, then that means that you are not a form of abolishment. It talks about it in the example of forced airship, where it says that any type of forced airship that would still exist in a world where you claim that forced airship is abolished means that it has not been entirely abolished, which proves why you still leave certain forms of plea bargaining in place, every single form of plea bargaining except for DNA, which means that you do not meet our interpretation. Now the counter interpretation of only your affirmative, no, ones that all labs can end up saying this, which means that the limits arguments can still end up applying because of the fact that everybody will just say, only my interpretation, only my app is topical. 2, cross-apply to arbitrary and self-serving. No reason why your app is necessarily key to being able to have good discussions, and no reason, there's also no reason as to why you're, actually, yeah, that's fine. The next counter interp, this is where we're going to do the job. One is that we only had 10 minutes to be able to prep this out, even if you give us your interpret the plain text. It was still a new app. Maybe it was still a new app. It's impossible for us to be able to prep it out. 2, it's a question of norm setting, which was conceded coming out of the bottom. The theory, of topicality, which means that we should be able to set a good norm. So maybe even if you would disclose it with the interpretation in the plain text, there are tons of other apps who would disclose it, and it would still be so small that you can prep it out. 3rd is that solvency applicants don't solve. 8, there are solvency applicants for an infinite number of proposals. Topicality should be the litmus test for legitimacy, legitimate solvency applicant. B, and this doesn't solve our ground office. Even if someone advocates for the position, that doesn't mean there's a reasonable ground against it. 4 is that you don't meet your own interpretation because the card that you point to doesn't say that we should abolish, that we should only abolish that form of plea bargaining, and that we should keep all other forms of plea bargaining, which means that you don't have a solvency advocate, so you don't access a counter interpretation under that. Now, the over-limiting offense, back in the document. 1 is the first stable plan mechanisms to be allow different ages and processes to abolish plea bargains. For example, which means that there are tons of different apps. It's not just one app that you could read. You could do things like refusing to plea, for example, because we don't mandate in our interpretation that you necessarily have government adjure. All we say is that there has to be a form form of abolishing plea bargaining as a whole, which is one example of an affirmative argument is that you can use different agents and processes as long as you get rid of all plea bargaining so we can get access to stable decide ground. For example, I wasn't able to read the budget decide that I would have otherwise read because you don't get rid of all forms of plea bargaining through whatever process or mechanism. Even gerrymandering had a very weak link, and so did federalism, because of the fact that both of those were meant for whole res affirmatives, and you're so tiny that I couldn't have reasonably prepared you out. And this combined with different advantage grounds gives the F plenty of leeway while encouraging the negative is never unprepared. The best debate topics allow a small number of large affirmatives, and even if you don't buy the arguments about different processes, this proves the different advantage areas proves why there's still a ton of different debates that we can end up having. Two, it encourages research. You have to dig deep to find good cases better than shallow case of weak research and better models academia in the real world. Three, is that bias. Overwhelming literature bias says police are bad. Overwhelming is only a problem that starts from non-viable cases, and then it has to scramble. It's crucial to keep the topic small. Four is alternative development. This topic is one of the biggest topics in history because of the fact that there's so many different kinds of plea bargaining. We'll listen back on our interpretation proper. Voters clearly picked actually skip that last argument, but now on the interpretation proper. Quick people who extend our interpretation on both means all that only means a subset. They only did it for DNA plea bargaining arguments to abolish all forms of plea bargaining. Now, the reasons to prefer the interpretation were conceded. First is the Harvard 98 evidence, which indicates that when you don't end up abolishing plea bargaining, there's no set minimum for what is the smallest amount of plea bargaining that you can end up abolishing. It says that you explode the limit because there's no minimum as to what abolishment would mean. If you allow for something as small as his act, which means that people could go as small as abolishing plea bargaining for Donald Trump, for example, which means that we would never be able to have reasonable ground if you were like abolish plea bargaining for JNA, for example. I could not be able to debate these kind of tiny acts which he would end up justifying. And the second argument you conceded is the SPCC card, which is really damning on the limits argument because it proves why there are so many different kinds of limits. There are violent crimes, property crimes, white collar crimes, organized crimes, and consensual crimes. And each of these have over 50 different types of crimes of subsets. For example, violent crimes include homicide, aggravated and simple assault, rape and sexual assault, robbery, while property crimes include things like burglary, larceny, motor vehicle theft, and arson. All of these explode the topic, and we could never be able to reasonably cut them out. Now, on his offense, back in the dock. All picks. One, picks are inevitable versus specific crimes. We can pick out of race or gender versus specific groups. We can pick out of crimes. Two, background, pussy, cold, means different from pick. And then just an answer picks out any advantage that says plea bargaining back. Bob doesn't answer allow plea bargaining to valid. Sally counterclaim, but an advantage that said plea bargaining to legitimacy would apply to any case. The aspect person gets to define the terms of the debate. Top counter limits are adequacy that still allows strategic innovation. Also, you make arguments why, for example, also on picks you can make textual versus functional competitions. You can also make arguments as to why there's a legal precedent outside. Three is that case in small case specific exception encouraged absurd. Gender second perception is creating masculine rather than engaging topic education always at the industry. We engage the topic every 2 months, and then fourth theory check wanting our consent of some means you can check the cheese every round. Five is fixed on the legal topics of crimes of legal system is second precedent distinguished general like even the price are about in general the majority of the literature on this topic they are crucial. Six is use arguments to the future judges and against the case to solve set of reason objects even to be over minutiae is inevitable. It's better to have large activists and equal about discussions. Now you say that switch out debates also that's illogical. Just because you want to do prep more prep doesn't mean that like people in small schools are able to do that much prep too. You can see that it's an unreasonable amount of prep. Now you say there's no internal link to engagement. Now we're arguing with your app is definitely too small for us to be able to engage it. There's barely any topic on there's barely any literature on this app, especially proven by the fact that you don't have a solvency advocate that you need to say. Now, the fairness and no fairness for education voter inside of the 1 and C. Obviously, we made arguments as to why limits is a good thing and why we should be able to have a reasonable debate based around a stable point of discussion. We don't need to explicitly say fairness is a voting issue because of debate, otherwise judges can't vote for themselves or something like that.
I have
59 seconds.
59 seconds now.
Long-term life advice, trying to become the president of the fucking Jesuit League. Bullshit. Fucking been begging people literally since May. Can you guys please host our state qualifying tournament so your kids can go to the state championship tournament? They're like, nah. So I'm having to ask, I'm having to beg on my knees to Cal State Long Beach, who isn't in our league, by the way, if they'd be willing to book 35 rooms for us so we can host a damn IE.
Who runs that team now?
Devin Cooper. They actually just interviewed a new, PhD DOS.
Because Nick Russell was like...
He left.
Good for him.
He left. Look at he got a full, tenure track position. Bye.
Yeah, exactly. He was just my favorite part of that team. Yeah.
That's it. Order's going to be case to T.
in jail for innocent crimes that lead to more modern slavery than there was in 1860. Outweighs everything else. A point is strength of link. They have literally conceded this through the 1AR and also through they've also conceded all of these arguments, which strength of link comes first to determine the size of impact and also probability of impact. Also use ethics to make modesty between 3 and substance. That's the key to avoiding judge intervention. Obviously, if it is even close on the theory debate, you should just keep all the substances. I'm clearly winning all my arguments. Also outweighs on probability because are actually skip the argument now. We are winning the strength of link question, which is meta weighing question, which means it comes first. Everything else. T. Overview. You conceded jurisdiction is not a voter. That's because judges vote up non-top class all the time. There's no reason why I have to be grounded in the resolution. As long as my interpretation proves that it would be good enough for some debate, then you should probably gut check topicality and go back to something to extend the argument that jurisdiction is not a voter because people vote up non-top class all the time. Look at policy debate now. Off the interpretation proper. They straight up concede the second standard to our interpretation about depth of education. How if we are going to if we can defend whole res, people are just going to read a stacked F or something like that, which means we have like a discussion over 5 different contentions, whereas under our plan we have 45 minutes of discussion over one specific contention. I waste everything else because we cannot learn anything if we're going to focus on 10 different issues in one round, which means we are key to education. Some education is, so we have 100% strength of link to a whole standard on theory. Now. They have conceded the, let's go to the argument there. Extend the argument. They didn't read any voters in the 1AR. They say that doesn't matter because limits is still a good, voting issue, but it is not a voting issue in and of itself. It's only a voting issue insofar it leads to fairness for education. Insofar that no one has voted a fairness for education voter, there's no reason why I should be down for topicality. Topicality just simply isn't a voting issue, which means if they can win all the offense they want, they do not have a voter to link back to, which means you shouldn't drop the debater. Just go back to substance and know who's winning there, which is only what the app is. Now. Extend the second argument that switch side debate solves it. I have to prep out every single app and also frontline every single against every single next round, which means that I don't have more prep than you. So neither limit standard means there's no beast within the round. Obviously, so the only argument you say is illogical. You say just because you want to do prep doesn't mean the small schools want to. That misunderstands the argument. The argument that I'm making here is that no matter what, I'm never going to have more prep than you because simply the prep burden is. I have the same exact prep burden as you. I have to prep out like a case tag to my app and like responses to all the disads they can read against the potential app. Even if the links are small, I have to have disads. Because conceding a disad and saying no link, it goes away, is completely small. If theory is even close, which we have proved that it is, because they just don't have voters on theory, just go check it and go back to substance. Also, this one. Okay.
Fast. All right. As for me, I think this round was a little frustrating. I think there's like little things that are not being answered by either side, or some arguments that I think that should be extended that aren't. I think there should be an RVI read. I don't know why there isn't. I don't understand why there's not a counter interp extended in 2AR. I don't really know what model of debate I'm supposed to endorse. So I default to the 2NR framing of there's thousands of crime apps and 50 subsets, and like every day is like a new run-of-the-mill affirmative that no one can prep out. I think that puts you in a really bad spot if you're going for these sorts of depth arguments, because it's very hard for me to buy that we will actually end up having a quality discussion when it seems that the topic is already so broad and you let people get away with literally whatever they want. I think the depth debate itself is kind of frustrating because I see offense on both sides and I see both sides not addressing the other person's argument. From the 2NR, I have you encourage small, shallow debates because you blow up limits. Our model encourages research, which leads to better cases, and all of the like, I can't prep this out ever, etc., etc. The 2AR is like, we can have a discussion over a bunch of things which outweighs because we have a discussion over one thing instead of 10. I don't buy the 2AR analysis. I think the argument about not being able to do the prep or not being able to come in and read budgets, gerrymandering, all of these like generic off-case positions, etc., would come prior to all of these like, oh, but wouldn't it be nice if we could have an in-depth discussion over one thing? Because I don't see how we end up at that point if her argument is true, which I definitely think it is. The response I get from the 2AR is, let me scroll down to it, is no, everyone has to prep out everything. I don't think that quite gets to the core of what of beating back the argument, because I think what she's going for is that certain schools just do not have the resources to prep like specific links to literally every app, et cetera, et cetera. So like, yes, even if we set the burden to a place where it's technically reciprocal, it seems like a lot of people will be pushed out or just won't be able to have the discussion, or at the very least the app will always be like 4 steps ahead of the negative, which means that there's not going to be any kind of clash, depth, engagement, etc. The voters debate gave me some pause. I don't know why standard voters are not thrown in. I don't know what the like strategic reasoning for that is. The one line I get from the 2AR is, this is an internal link, this is not a voting issue. I think that begs the question of what's the bright line for what is an internal link and for what matters enough to warrant the ballot. The way I hear it is that limits are a voting issue because it tells the negative what to do and what they have to be prepared for. I don't know why this is distinct than like education's a voter because it's the purpose of debate, fairness is a voter because debate's a game, etc. Why do 2 of these things matter and justify a ballot, but like the third one does not? Like, what is the delineation? It seems to me that like limits do matter. They are at the core of the debate. I don't really understand why not, and I think T comes first. So that's me.
Yeah. You're good to go too if you need to go. Sweet. So I do agree that I think that you could have like lost this round, and you know, if we did this 100 times over, there's a world in which that could have happened. And I think that is on the question of the voter. I do think there is a voter in the end of her speech, and she kind of goes for like, and limits are key to like setting precedent in rounds, right?